Okay, hello everyone. This is a work group 3 meeting where we will be hearing from Commissioner Grant regarding his proposal with myself and Director Gray. Tierra Thomas is also here from the Charter Commission's ex officio member and members of the public who are present for discussion and presentation regarding the proposal that may impact the work of the personnel director's article that Workgroup 3 is looking to recommend or start discussion on for the public effective tomorrow, that you probably should already have on the commission's website and distributed to you via email from the Charter Commission staff prior. Today's meeting or work group session is definitely not to duplicate anything that's going to be discussed at the April 1st meeting. It's to give Director Gray, Commissioner Grant, myself, and Tierra Thomas that is present, as well as members of the public, the opportunity to brainstorm what the proposals and how they will impact and affect each other. So I will mute myself, yield the floor to Commissioner Grant and Director Gray and any members of the public who would like to participate in the discussion pertaining to Commissioner Grant's proposal. You should have received it already via email. So Commissioner Grant, you don't have to read it verbatim if you don't want, if that's not your desire. We've all read your proposal prior to the meeting and when you sent it originally at the top of the month and the update. So the floor is yours.
Okay, sure. Thank you, Madam Chair. And I do have the ability, if you want me to, I could share screen it, if you'd like me to do that. Would that help people, or does everybody?
Yes.
Okay, I could. So there, I think that should be on the screen now. Okay. So thank you. Yes. This is a proposal. It was not, I'm in another work group that deals with BPS and finance and E&A. So this proposal is not has not have anything to do with that work group. It's from me alone. And it relates to, although I have discussed it with Jake Hummel, non-voting commissioner member, and he supports it as well. And it relates to the right to collectively bargain, organize and collectively bargain for city employees. And currently there is an ordinance in the city that sets forth a process for collectively bargain recognition and collectively bargain contracts with city employees. There's also, for context, in Missouri, there is a provision in the Constitution, the state constitution, giving the right to organize and bargain collectively. It's actually Missouri's rather unique, one of 3 or 4 states in the country with such a constitutional amendment. So you might be asking, why do we need this if there's an ordinance and also an existing provision on in the Constitution? And that's, I think they're both legal and policy reasons for this proposal. The legal reasons is, one, that the existing ordinance, while helpful, is just a basic framework for bargaining agreements and really doesn't deal with issues involving adoption of those agreements and how they apply over their duration. The second thing is that is with respect to the Missouri Constitution, is that the language in the Missouri Constitution is one sentence, and it doesn't have the detail that is helpful when actually implementing the right to organize and bargain. So I have come up with this proposal. And further, for that matter, like we have seen very often efforts by the current majority in Jefferson City to override local control. or to alter state law in order to um, restrict the ability of cities and counties from exercising their powers. So I felt it necessary and helpful to include a provision in the city charter, which to the maximum extent possible would protect this right to organize and bargain collectively, which I believe is, and which many courts have said is a fundamental right for public employees in this country. And so what I've done is set forth this proposal, and this proposal is really the first sentence just sort of sets forth the basic principle of the right to organize and bargain collectively, and then sets forth a process in the following sentences for how recognition of labor unions as exclusive representatives, which is the model followed by states and by the federal government, in which the union operates as the representative for employees for which it represents in regard to bargaining wages and benefits and other terms and conditions of employment. And then it sets forth in some of the following sentences how the ultimate agreement between the city and the representative is reduced to writing, adopted, and implemented. And this is maybe the most important language in this amendment, because state law does not really speak to this issue. And further, there have been problems in the past at the city of St. Louis level where agreements are reached between the city, generally the mayor's office does the bargaining, and a labor union, but then just sit at the board of aldermen for months and months and years without action and don't get adopted for whatever reason. And that's an interference with the right to bargain. So this sets forth a process by which the board of aldermen should take action within 60 days. And if it rejects it, sets forth the process for how it's the agreement is returned to the parties for further bargaining, and then explains, like, when it is adopted, that it's going to be signed and then is considered binding for its term, notwithstanding or superseding any contrary city charter provision. And that might seem odd to you, but it's actually addresses a problem that labor unions have faced with the city in the past, where depending on the city councilor's office at the time, they've taken the position that even the provisions in accepted collective bargaining agreements aren't enforceable because they somehow contravene a provision in the existing city charter. And most often that arises with issues with existing civil service rules and whether a collective bargaining agreement can alter those rules, for instance, provide better benefits or provide alternative methods of dispute resolution, such as grievance and arbitration procedures to resolve questions about interpretation and application of a labor agreement. So I say all this, I should have said beforehand. So I have my practice is I represent labor unions, and I've dealt with the city quite often in the past. And so I'm very familiar with these issues that arise in dealing with the implementation of the right to organize and bargain. And this proposal, is really, like, it's a product of over years of experience of lawyers in the community and of addressing issues that arise with bargaining with the city and implementing contracts. Now, that's sort of the legal perspective. I think from the policy perspective, it's why I think this is a really good proposal is that it enshrines in the city charter a very important value, and that's collective bargaining, and that the city, it's a recognition by the city that its employees should have a voice in the workplace and the ability to act collectively through a representative, through a labor union, to bargain terms and conditions that are appropriate to them. Much of the language, about bargaining and recognition and what matters or subjects of bargaining, that tracks existing federal and state law. So this will just further enforce what can be accomplished under analogous law. And also is a policy matter. It's my personal belief, and actually one I think that many studies and from academics support as well, that collective bargaining as a value is beneficial to the city, to the workers, and to the public, because it's through collective bargaining, through this give and take and negotiations at the table, that that the city and workers of a particular department can collaborate and develop solutions to problems that they are facing on a day-to-day basis, and come up with narrowly tailored and specially crafted solutions particular to them, that can be beneficial to the public and to the city as well. Because you can address issues like, how do we cover staffing for trash pickup, or what sort of safety issues are important that will lead to the reduction of accidents, or what can we do to recruit more employees. And so through that collectively bargained process, you can establish these tailored solutions to very specific issues, to attracting and retaining workers and increasing morale. And it also provides a dispute resolution procedure outside of litigation in the courts, which is not nearly as expensive and quicker and more efficient, and thus saves money for taxpayers over time. Further, it's been my experience, and also supported by a number of studies, that collective bargaining supports gender and racial equity in the workplace by ensuring fair wages and fair treatment, right? And giving all workers a voice in the workplace through the representative. So as a matter of policy, I think this is a very good thing for the city as well. So one thing I do want to mention is, just because people often complain about collective bargaining in the public sector, is to be very clear, this provision does not obligate the city to agree to anything, right? It doesn't set forth any particular system, any wage rate, any benefit rate. It doesn't require any particular dispute resolution procedure. It doesn't require increased contributions to any pension or retirement fund. None of that is set forth in here, because that is the whole purpose of collectively bargaining, is that any party, they can present their own solutions, and that either party, the employer or the employees, can't be forced to agree to a particular provision, right? So, a union could present a proposal for instance, a wage increase, but the city is under no obligation to, or no legal compulsion to, agree to any particular proposal. They can bargain, and in good faith, if they have sound reasons and rationales for rejecting a proposal, it's too expensive, it's unfair, it creates upward pressure for increasing the wages of other employees that the city can't afford, then the city can, in good faith, refuse to agree. So all it requires is just what is required in federal law and state law, is just to bargain in good faith with each other, but not to agree to a particular proposal. So that's why with all that said, that's why I've proposed this, and why I think it's good for the city and its workers and the public. And I hope it could get support for the commission to be added to the charter.
Thank you, Commissioner Grant. I'm going to ask a few questions, and then I'm going to yield the floor to the member of the public that has their hand raised.
Okay.
And we'll
Madam, I'm
go
sorry,
ahead, Director Gray.
Madam Chairperson, before you begin with your questions, just one point of clarification, as we move forward, with the agenda item, and that is concerning, that the mayor's office, has the authority to negotiate. That is a bit, that's not completely accurate, because by charter authority, the director of personnel is the only chief negotiator, on the side of the city, and the only one that actually has the authority to negotiate on behalf of the city. And so the mayor's office, provides advisors, to the committee, but the director of personnel is the only one really by charter authority that has, negotiating authority for the city of St. Louis, in which the Department of Personnel or Director of Personnel operates in an independent, from the mayor's office. The mayor's office primarily is heavily involved in the financial aspects of negotiation, but as far as language, content, et cetera, that's negotiated by the appointing authority and the director of personnel.
Thank you.
Okay, yeah, I mean, yes, the director of operations historically has played a major for the mayor's office has played a major role in negotiations, but the personnel department does exert authority ultimately in that process as well.
Okay, I'm going to yield the floor to Renee Tyler at this time.
Thank you. Can you all hear me? Can you hear me?
Yes.
Yes.
Okay, great. Thank you. So Mr. Grant, I really appreciate your presentation as well as yours, Director Gray. I have a couple of questions though, with respect to what you're proposing. How does this, what is different from what is currently included in the Code of Ordinances, specifically Area 15.170.060, which deals with collective bargaining? And also, I have perused the employee handbook, which I believe, and Director Gray, you can correct me if I'm wrong, also outlines collective bargaining. And the other question I have, you're referring to all employees in what says employees. Who specifically are you referring to within the structure of the city? Because I know fire, police, and I would imagine public works, and a few others are already under union, under unions. So what's different specifically with what you're proposing than what's already on the books?
So yeah, so that's a good question. So one, yes, some of this stuff is already quote on the books as an ordinance, but obviously that can be altered or modified by the Board of Aldermen with approval of the mayor or overriding a veto at any time. This would actually enshrine the value of the right to organize and collectively bargain in the charter itself. So that gives actually the ability to the enforcement of those agreements. It makes it much easier to do that. But and where this also differs from the ordinance itself is that, so one, it enshrines the obligation to duty, the obligation to bargain in good faith, which is been construed, but Missouri courts have construed that obligation, but that's not as quite clear in the existing ordinance. Second of all, it clarifies what happens after a completion of bargaining, that is not in the ordinance right now, and it doesn't indicate, the ordinance doesn't indicate right now what happens when the collective bargaining agreement is referred to the Board of Aldermen and nothing happens. That's a problem. And so there needs to be a process by which the board either acts to adopt or modify or reject the agreement, in which case, or if it doesn't act, that the agreement is deemed modified, adopted. It can't just, that's one thing. That's the problem right now is sometimes these agreements sit for before the board and never get adopted. The third thing is that it details who needs to sign the agreement and how, and it makes explicit that it's binding for its stated term. I don't even think an ordinance can necessarily do that, or at least that's a matter of law, and I think should be enshrined in the charter. And further, it makes clear that the agreement itself would supersede any contrary charter or ordinance provision. So that would be, for instance, a civil service salary schedule or something like that, that if the parties are able to agree to wages that are different, that those should apply.
So are
Now,
you,
okay, so that was the first question you had. Do you want me to, I was going to ask the question about the question about the employees as well, or do you want to follow up on that first?
if you don't mind, so I just want to be clear. So are you taking the stance that ordinances are not law
No.
that govern the city?
Yeah, no, but yeah, a charter provision is more powerful than an ordinance.
I'm sorry, repeat that.
Well, a charter provision is superior to an ordinance.
Well, charter provision provides the overview for how you govern your city, but ordinances are often, it's like comparable to amendments to the Constitution, right? So at the end of the day, I guess I'm just trying to understand, and I think I do get it. At the end of the day, it sounds like what you're proposing is you're saying that the ordinances, I'm sorry, not the ordinances, that bargaining agreements that are pulled together and agreed upon at that point between the union and the city. And then they should be presented to the board of the alder people for their vote. So you're saying that the alder, it doesn't go on the agenda? Is that what you're saying? And that the contracts are not voted on?
It's been my experience sometimes in the past that they're not voted on.
Do we have, Commissioner Grant, do we have documented, I'm going to say research or something to support to that end?
Yes, sure. I mean, I've known that agreements between various, like for instance, the police union in the city were never adopted by the Board of Aldermen. And I believe that to be the case with a number of agreements between, in the past, between various building trades, like the electricians and plumbers in the city, that
Right.
they were just established as policy, but never
Okay.
actually submitted to the board.
So to answer your question to me, Chairwoman Nolan Eccles, the Department of, I do not currently have research, but I can look into that. But for a point of clarification, the Board of Aldermen has never had responsibility for approving content language of a CBA. Their primarily role and responsibility is the approval of the compensation pieces of it. And if budgets have not been approved or financials are not where they need to be for the city to be able to move forward with those types of things, I could see how that may have held up the approval of CBAs. But at no time has the Board of Aldermen ever had responsibility for the overall governing or approval of a CBA. The other thing, for point of clarification to Ms. Tyler's question, is that the information that has been provided that this recommendation would cover, that language and those things are automatically covered in a CBA. The CBA will determine and it dictates how long the contract will be in effect. It also controls, again, the pay schedule. It controls the employment policies by which the union will operate. So those things are already built into the CBA. So when it would go to the DOA for the compensation approval, The contract has already been ratified by members. It's already been signed off on, and it's good to go. It is just needed for monetary approval.
Well, that's very interesting because that's the city councilor's office has taken a different position in the past than what Ms. Jenkins Gray has said. So that's part of the problem, I believe, is, you know, so look, state law right now requires that any agreement between a city and its labor union dealing with employees of the committee needs to be submitted in whole, not just the compensation elements, in whole to the public, the governmental body, in this case the Board of Aldermen, for approval, rejection, or modification. So the fact that, I mean, and in fact, I've been informed in the past, many years ago, not the current city councilor's office, that that certain agreements were submitted and never acted upon. So I think we need to make clear that, and I think it's one helpful thing about this provision is that, you know, that this ordinance is going to essentially make sure, or this charter provision is going to make sure that, consistent with state law, that the contract as a whole is submitted to the board for approval, rejection, or modification. Now, all of that said, this does not set forth, like, so for instance, in this current proposal here, if the personnel director retains authority to actually serve as the negotiator for the city, that won't change, right? But it would require submission to the Board of Aldermen. I think, you know, what's also important is Ms. Jenkins Gray does point to a very good point, which is like this, it's, you know, obviously what the board is generally most concerned with is the finances, right? You know, the wage, like, what is this going to cost? You know, and that's very often with any long-term contract that the city enters into, right? That can span years, whether it's a construction contract or a service contract or a vendor contract. Sure, the board, you know, ultimately needs to appropriate money to fund that contract for its duration. So that, I think Ms. Jenkins Gray is right, is that it historically that has been the board's role. And there, but nothing would change about that. I mean, I think that's something the board, when they look at any contract, whether it's a labor agreement or a vendor contract, and they're looking at the cost over a term of years, they need to make sure that it's a wise use of the city's resources and that the money is there to pay for it.
So Commissioner Grant, in reading this and then listening to you now, I'm hearing a lot of processes that are issues, which is why via email I requested the meetings that I've requested pertaining to the mayor's office, where the operations and things are handled and taken care of, because I believe that the concern coming out of this proposal is truly due process and what the process is, and having it followed, given what is currently on the books, because it sounds like it continues to be an operational issue with certain things that come up at the forefront. Do you believe, by way of reading the full charter, that collective bargaining is not present and is not a governing aspect of the city of St. Louis currently?
I would say my experience is there have been problems in dealing with the city and in engaging in bargaining in good faith for reaching agreement that's obviously adopted and implemented and enforced. And that's not an issue about any particular individual or stance. It's just that the personalities over time change, right? Administrations change. And I think we need to recognize in the charter, we need to recognize the value of the right to organize and collectively bargain, and not make it subject to any particular personality or interest in the city at one particular time, but ensure that this is a statement that we value as a city, our city employees, enough to recognize their right to have a voice in their workplace. And regardless of who's the mayor at any particular time, or, you know, who's a supervisor in a department at any particular time, that we need to make sure that there is continuity in the ability of employees to voice collectively their desires to change and improve their terms and conditions of employment and put that in a binding contract.
Well, that's what I'm asking. Are you saying that that is not present in the current language of the charter?
That's right. It's not present.
Okay.
So, and then I want to go back. I don't want to Miss Tyler had a question. I don't want to like think we missed that about who an employee is. And I don't know if she still would like me to answer that.
Yes, please.
Okay. So, employee has a very common meaning as under state law and under labor law to generally encompass non-supervisory employees of an entity. So that it typically means someone who doesn't have like the power to hire or fire or discipline or assign hours of work or responsibly direct duties. And that's how historically that term is interpreted. So that includes, generally most of the basic workers for the city right now who are, in refuse and streets, in the correctional center, in who police and fire, it would. I mean, I think I can't say for sure where that line stops, but it would not include like upper managerial people. It's not.
So I'm sorry.
Yeah.
So no, I absolutely understand that, and that's why I listed. I understand who's covered under union, but I'm trying to understand though, per your statement, using a blanket statement, term employees. Are you speaking of unionizing the city? Because just in listening to you, that's what it sounds like. And if that is the case, and I'm not anti-union, I'm very pro-union. I know that managers, directors, whatever, are not included in the union, but I'm just trying to understand who all are you talking about covering? Because again, there is language in several places throughout city documentation that covers collective bargaining. And I'm even now trying to dig to see on paper where the city of St. Louis has been anti-union, I've negotiated contracts, so I totally get what you're saying, and but there are instances, and it sounds like you're saying if the contract is not approved, then you're lobbying for or advocating for the right to just approve the approval. And if maybe the contract's not approved because financially they can't afford it, and if that's the instance, it should go back and they would renegotiate it. So are you talking about everybody in the city that's not that's not in management? Because even like you said, electricians, and you can be a what do you call it, a supervisor, and you're still in a union.
Yeah. So there are various levels of employees in the city where someone is an employee versus a supervisor. That's an individual determination, which I just
No,
can't.
I don't agree with you on that. It's not an individual. It's usually lined out who's union and who's not union, and I'm sure they have that lined out somewhere. I'm not trying to be argumentative or anything like that, but it's normally laid out who can join. Because if you're the director of whoever the director of public works is, they're not in the union.
Sure. So I'm not sure there's a bright line, but I think generally, we understand that employees who'd be covered by this are sort of the employees in the field, driving the trucks, filling the potholes, employees in offices in City Hall who are doing like the clerical work or the basic administrative work or the secretarial work. It includes like the beat officers. It includes like, the firemen and women who are on the trucks and driving the trucks and putting out the fires. And it includes, so this would encompass people who currently have a bargaining representative, which includes some, but not all employees of the city. So for instance, at the correctional center, the carpenters are currently the representative of some of the correctional officers there. But there are also a large swaths of the city that are currently unorganized and don't have a representative. So they would have the ability to organize and bargain through the process set forth in this proposal.
We have a member of the public, the title is Command and Shiners PC. I will yield the floor to you.
Hi, this is Emily Perez. I apologize for the name on the screen. That's the default on this account, and I couldn't change it. I, like Chris, am an attorney that represents labor unions, including labor unions in the city. And I just wanted to first make a couple of comments and then ask Chris a question. First of all, I just want to underscore what Chris has already said about the importance of having this policy encouraging collective bargaining enshrined in the city's charter. Right now, the city charter makes no mention whatsoever of collective bargaining. I do believe it's vitally important that it is there in our charter and not just in an ordinance. And also to sort of elaborate a bit on what Chris was trying to explain about the applicability of this to employees. Yes, there are certain groups of employees who have already organized. They have their own different unions. Most of them, with the exception of police officers, have been certified by the Missouri State Board of Mediation as the bargaining representative. There is a process that groups of employees who wish to unionize must go through before they are granted representative status. So while the collective bargaining ordinance today, or the collective bargaining language that Chris is proposing, would apply just to the currently organized employees, it could apply to other groups who did later decide to organize through their own representative and gain representative status. So it doesn't necessarily have a direct and immediate impact on all city employees, but could affect many currently non-organized employees. I don't know if that's helpful or not, but
So I
Chris,
think that's my concern. Go ahead, Emily. Sorry.
No. Go ahead, Chairwoman.
I think that is my concern, because everything that we put forth out of this commission and every commission after us has to be about all, the total, the complete, the reflection of everyone that it could or could not impact. The current charter has a way with this language to compartmentalize areas of importance. This has to also be something that does not further that language. And so in listening to your contribution to the proposal that we're looking at with Commissioner Grant, it continues to not be clear if it is for all city employees or for select city employees, and identify which one it is and which ones this reflects. Because from my very honest opinion, I cannot be in favor of something else in the city that is not for all.
Yes, and I
also keep hearing the word policy and the word process. The charter is not either of those two things.
Well, on the first concern that you have, and perhaps it's because Chris and I live and breathe this area of the law, and it tends to be pretty obscure to others. I think that it's easy for us to understand that this does apply to all city employees, right? It may not do so immediately, but it secures employees' rights to later decide that they want to organize and bargain collectively. And I think that's very important. And I perhaps disagree with you a bit respectfully, Chairwoman, on the charter not setting forth a policy of the city of St. Louis. I think that in a way that is what it does, and that's why we have our citizens all, vote to approve charter amendments. But that's an aside. I wanted to ask Chris one question with respect to the proposed language, and it has to do with the Board of Aldermen's ability to modify a proposed agreement. And before I ask that question, I just want to also concur with Chris that having collective bargaining agreements enshrined as ordinances by the Board of Aldermen is incredibly important from an enforcement perspective. That being said, Chris, with respect to the Board of Aldermen's ability to modify an agreement, is the intention of that language that the Board of Aldermen could rewrite any of the terms of the agreement, or simply send the parties back to the table on perhaps a portion of the proposed agreement?
It's the latter. So
that's what I figured. I just wanted to make that sort of clear.
So the phrase adoption, modification, or rejection is taken from current state law, section 105, 500. So, and in drafting the proposal, I felt it, if that's what the current public sector law says as to what happens upon agreement, that it's referred to the public governmental body for adoption, modification, or rejection. I felt it important that we track the language of state law there. I have always understood those terms to mean, the modification term to mean that if, for instance, the Board of Alder persons could look at an entire proposal, believe that it's acceptable, except, for instance, the provision dealing with overtime pay or something, they could say, we can't accept it as that, we wish that to be modified, and then it shall be, then it would be returned to the parties for further bargaining, not that it could be unilaterally modified. And that's why I put in here, in the event of modification or rejection, the agreement shall be returned to the parties for further bargaining. So
thank you. I just wanted to I thought it would be helpful perhaps for Director Gray and the commissioners to flesh out that point and understand that we're not giving the Board of Aldermen the authority to rewrite the negotiated terms that are before them. Yeah. And that's I think all I have to say. So thank you to the commissioners for allowing me to speak. And thank you, Chris and Director Gray, for your time today.
Thank you. It's Madam Chair, if I could just, you were making the point about, you wanted to make sure that the proposal reached to all employees of the city, and that is the intent. Both currently organized and currently unorganized employees of the city would have this right to organize and bargain collectively, which by the way doesn't mean that it equally respects the right of someone to choose not to have a representative. I mean, and Ms. Perez referenced this. There's a process under state law right now by which labor unions are selected through elections which are monitored and processed by the State Board of Mediation, in which all eligible employees vote. And if a majority of the voters select the union as a representative, then it's certified as the exclusive representative. If they don't, if a majority of employees do not select or vote for the representative, then the union loses, and there's no union. So those rights would remain the same. I think the use of the term employees, I just wanted to make sure that there at some point, any employer, including the city as an employer, as a public employer, has to have certain individuals who have to actually make the management decisions. I think I probably, the personnel director would agree with that. At some point, there has to be someone who actually is engaged in the bargaining and making the supervisory decisions that can't be covered by these labor agreements. So that's sort of the distinction. That's the use of the term employees there.
I think I'm gonna state this piece, and then I'm gonna yield the floor to Tiara Thomas and then Director Gray had her hand up as well. It's that we have to be very mindful of the framing and the wording and making sure that it's clear and it's concise and that it's been researched and it's accurate. It's not coming from a space of any form of relationships that we may have as commissioners by way of the proposals that we put forth, because these things are implemented by the bodies of the city that obviously have to see them through. So we want to make sure we're doing our due diligence. For myself, I'm not necessarily concerned with the agreeing or disagreeing of different proposals or recommendations that we have. It's just important that we make sure that we're covering all bases and we're making sure that all individuals that could be impacted or affected by anything is being referenced. And then, as you know, you've been a part of some other meetings, Commissioner Grant, where I too have to make sure that recommendations are not policy and operations and are in fact governance and belong in the charter. So identifying other charters that have collective bargaining within their language, within the article in which you're looking to put it, within that particular section, et cetera, is also important to this process while we're advocating for certain things. We just want to make sure we're covering all bases.
Okay. Sure.
Member Tiara Thomas, thank you.
Hi, Chris. So my comments are basically just looking for you to clarify my understanding of what your presentation was. So from my understanding, and correct me if I'm wrong, collective, I'm sorry, Director Gray.
Nothing.
My understanding of collective bargaining is that it really only is relevant to those who are unionized, correct?
So I think I understand. So
Well, let me reframe the context. I know the argument here is that it wouldn't be, seems like this proposal that you're bringing forth is something that would exclude others. It wouldn't be covering of everyone and all employees, and it has the potential to exclude people. But from my understanding, this collective bargaining proposal that you're bringing forth would only cover the people who are already unionized or seek to be unionized in the future.
No, it would also cover employees who are currently not organized, don't have a labor representative. And there are some of those in the city. So it would cover them. It would give them the option to select a representative if they chose, or it doesn't get into the details about the process for selection, because state law generally covers that right now. Or that could be fully fleshed out. That could be more fully fleshed out in the ordinance. But yeah, so it would cover both unionized and non-union employees.
Okay, so this wouldn't exclude anyone, or to your knowledge currently as it's developed?
No. no, no, I mean, like, so for instance, it doesn't exclude any particular category of, all you have to be is employee of the city. It doesn't
Okay.
exclude any particular subcategory of employees of the city. So it doesn't, like, for instance, carve out, except for secretaries and the who work for BPS. It doesn't do that. So
Okay, thank you.
Director Gray.
Well, thank you. Thank you, Attorney Perez, for your comments. And Ms. Tyler and Thomas, for everyone. Mr. Grant, Chris, just some additional thoughts that maybe you could help me understand how you see that this would work. And also, I never made the official statement. I am not against collective bargaining, and I believe as well that it should be clear and documented that the city supports collective bargaining. But when I begin to think about risk factors, there are just a couple that come to mind that I'd like to understand how you would see this would work, or if you see it as a potential risk. And so, I mean, it's well known that a lot of elected officials, they are actually backed by unions. Unions give money to their campaigns, etc. And especially within the BOA. So do you perceive or see that there would be a risk from political influence into the collective bargaining process with ratified contracts that come before the BOA for approval? And one of the things that I have learned about, or I'm learning about a lot of the language in our charter, is to minimize the impact of political influence, corruption, those types of things as it relates to the employment of individuals, whether it's collective bargaining, whether it's personnel decisions, etc.
no, I with all respect, no, I don't see this as creating an issues with corruption or undue
Or the
political
potential
influence.
of, not saying
Yeah.
that anybody would, but the potential
Yeah.
of those types of things
Yeah.
happening.
Or undue political influence by
Mm.
unions over elected officials. I mean, for one, I mean, it's this, this doesn't change the status of any particular elected official or from where he or she stands right now. And so, and two, I always expect the city and to operate in the best interests of the taxpayers and of the city. And they do that in every official act that they undertake, whether it's negotiating and entering into a contract with a street paver, or whether it is with a labor union. They are expected, and I think they do negotiate and engage in those discussions in the best interest of the taxpayer. So I don't see any particular evil or danger from this proposal as different from any other negotiations that take place for the city right now.
Okay. Then my additional question to that, being based off of the information that you just provided, around the expectations of the city, that we operate in good faith, that this is not any different from any contract with someone coming in and paving the streets, etc. Then why does the concern exist that our current process would not work with some tweaks and some modifications to how we do things to be able to avoid contracts sitting, for long periods of time? Then why would our existing process not work based off of what you just explained as the expectation of how the city operates?
Sure. So again, the purpose is to sort of enshrine this right within the charter, which makes it, I think, is as important as a statement of value, and also makes it less subject to the shifting personalities of people who fill particular positions at a particular time. This also does something that's not in the ordinance right now. It does enshrine this obligation to bargain in good faith, which exists under the state constitution. So it just mirrors that. But it also goes forward. It sets forth, it explains what's supposed to happen when this agreement is either adopted, modified, or rejected, which it's just this has been a perennial problem, and Ms. Perez can speak to this, a perennial problem with no matter who is serving in the city, in the mayor's office, of getting these agreements adopted and implemented and enforced. And it makes clear that like we are going these labor unions, because again, this legal advice can shift over time. It makes clear that the unions of the city are going to be able to bargain about and enter into agreements about hours and wages and overtime, and those are subjects which are important to a labor agreement, and that the parties are going to have an obligation to bargain in good faith over. They can't simply just say, I refuse to talk about these wages, or I refuse to talk about overtime pay, and that once they reach an agreement that it will be enforceable. And that the purpose is not to denigrate any existing I'm not, it's not, I understand this. The mayor has said very often that that she supports collective bargaining, that her office supports collective bargaining. I very much appreciate that. But it's important to enshrine these values in the charter. It's important to make sure we have a process that creates binding and enforceable agreements. And it's important to have language that survives any existing administration. So
okay, and then my last question, the last point is, when it comes to the language that mirrors what's in what's written for the state, you mentioned that you kind of just mirrored that, and the wording that you used was modification, etc. And we all know in any type of legislation or contract, etc., words are very, very important. And I think it needs to be clearer that those words for us does not mean that the BOA has authority to come in and not approve a ratified contract, because that's not what the language implies as it is currently written. It implies that the BOA has the authority, once a contract has been ratified, approved by membership, that the BOA can come in and not approve the contract. And so I think that the language that's currently there should be modified to represent what actually cannot happen. So I think that's.
So I am certainly, I am certainly, if there is language that's not clear and needs to be modified to properly reflect the intent, I think we need to do that. I absolutely agree. As I was explaining to Ms. Perez, like I took this language out of state law, and as Ms. Perez mentioned, this is a subject that I deal with on a day-to-day basis, and so I perhaps have these assumptions just built into my mind as to like what the meanings are that I understand that it may not be clear to others. So I would certainly be willing to, if there are modifications or changes or amendments that would make it more clear, I'd certainly think that's a good thing. So.
I also want to, the time is 2:00. I want to ask some of my questions, but I want to address the aspect of what is clear to us and not clear to others. We've had several special meetings from individuals that have, I want to say, criticized our use and choice of language in the existing charter and our city structure and different aspects of how we've chosen to assume that because we have or we understand professionally a set or a certain language or platform that others immediately or rightfully understand the same language. So we have to be with our recommendations. Again, I restate very clear and making sure that we've done more than our due diligence on what it should look like. Chris, I did want to turn your attention to Article 15 of the charter and ask you if you believe the proposal you have is more in alignment there or in Article 8 that you have suggested or recommended.
Let me get my charter, copy of the charter. Okay, so so you were thinking, I had put it in Article 8, which relates to the current article on city officers and employees. And what was your suggestion, Madam Chair?
I'm suggesting Article 15 if we're just making sure we're in alignment with the collective bargaining topic and perspective so that it's in the best place. If as a commission we vote and approve it, we want to make sure it's going in the appropriate section or place of the charter upon discussion so that it's within context. Along with that, I would ask Director Gray if you could, when we have tomorrow, actually, I'm sure there's going to be a continued conversation tomorrow and at the April 1st public meeting. There's the timeline and the process associated to collective bargaining. If you could provide that to Commissioner Grant for his total knowledge pertaining to his proposal, I believe that would help with some of the language requests that you're asking or you're requiring of us. And I think that that would help with some of the edits or changes that he may have to make over the next few days as this continues to be a discussion.
Okay.
So, and what was, Madam Chair, so Article 15 was your suggestion?
Yes. Do you think it
So-
would be a better fit in Article 15, or are you for certain Article 8 is where it should be?
I'm not particularly set on any article. Article 15 is the Department of Finance. That seems that doesn't seem a natural fit to me.
Mhm.
I mean, I can tell you that it could be in other articles. I guess it could appear within the I'm just trying to think here. I could appear, I guess there's an existing article on civil service. It could appear there. I think I'd have to think about that to make sure how that melds with other changes that are being proposed to that article
Yeah.
regarding the existing civil service system, or also the director of personnel. I know various proposals have been floated on that. And and by the way, I mean the whole, there's certainly this provision can easily work in parallel or in tandem with the civil service system. So for instance, it's very common in public employee labor agreements, for instance, to have a labor agreement that gives employees, in the event of discipline, for instance, a suspension or termination, the option either to pursue a civil service hearing or to pursue a grievance and arbitration before a neutral arbitrator. That is very, very common in states with robust public sector bargaining. So I could see it in the civil service section. I could see it in other sections. So no, I'm not necessarily wedded to Article 8.
Okay, so if we could, Commissioner Grant, you and I can work on this, or with the combination of other commissioners, work on where the best fit would be, so that when we're at the public hearing and public meeting in the next couple days, when the public asks, because you know that they will have the outline of the articles where these things are pertinent. If we could have some ideas on other places it would be best, or where the current or existing language is, and if we're doing an addition or subtraction, or like with the Department of Transportation article, we're doing a total new section, if it's a new section or if it's a support to a already existing article. So if we could do some of that, I think it would help ease members of the public with what the context is for the particular article, and the positioning of it, I believe, matters, which is why I wanted to make sure you had the time to see if it fits in the personnel director's article, for example, and what I referenced as snowball effect or impacts would be to this section of the article, of the charter. So just kind of putting that out there for you. And I am more than able and available to assist with the navigation of such. I do recognize that the time is 2:07, and with all due respect to time and all the members of the public, including commissioners and ex officio members that have joined us today, I want to thank you. Commissioner Grant, thank you for coming to Work Group 3 and presenting and hearing from Member Thomas and Member Director Gray and the members of the public.
Thank you.
Thank you all.